Understanding the Americans with Disabilities Act, ADA. The ADA and fair housing work together. In the previous section, we discussed reasonable accommodations under the Fair Housing Act and the importance of providing equal housing opportunities for individuals with disabilities. Another important federal law every Arizona real estate professional should understand is the Americans with Disabilities Act, ADA. Although the ADA and the Fair Housing Act both protect individuals with disabilities, they are not the same law and they do not apply in exactly the same situations. Understanding the difference helps licensees provide better service while recognizing potential compliance issues during a transaction. What is Title III of the ADA? Title III of the Americans with Disabilities Act prohibits discrimination against individuals with disabilities in places of public accommodation. This includes many privately owned businesses that are open to the public, such as hotels, restaurants, retail stores, medical offices, banks, shopping centers, real estate offices. The law requires these facilities to provide individuals with disabilities equal access to goods, services, facilities, privileges, and accommodations. Unlike the Fair Housing Act, which focuses primarily on housing, the ADA focuses on public access. Why should real estate professionals understand the ADA? Many Arizona licensees represent buyers and sellers of commercial properties, mixed-use developments, apartment communities, office buildings, restaurants, hotels, and other public facilities. Although real estate licensees are generally not responsible for bringing a property into ADA compliance, understanding the law helps identify potential accessibility issues that may affect a transaction. Recognizing possible concerns allows licensees to recommend that buyers and sellers obtain qualified legal, architectural, or accessibility advice when appropriate. One of the primary goals of the ADA is ensuring that individuals with disabilities have meaningful access to public facilities. Depending on the type of property, accessibility features may include accessible parking, accessible routes into the building, ramps or elevators where required, accessible entrances, accessible restrooms, appropriate door hardware, accessible service counters. These requirements vary depending on the property's age, construction date, alterations, and the specific requirements of the ADA standards for accessible design. Because ADA compliance can be highly technical, licensees should avoid making representations regarding whether a property fully complies with ADA requirements. Reasonable Modifications and Accommodations Title III also requires businesses to make reasonable modifications to policies, practices, or procedures when necessary to provide equal access to individuals with disabilities. For example, allowing a service animal into a business that otherwise prohibits pets may be required under the ADA. Similarly, businesses may need to modify certain procedures or provide auxiliary aids when doing so is reasonable and does not fundamentally alter the nature of the business. Each situation should be evaluated individually. ADA enforcement. Individuals who believe they have experienced disability discrimination in a place of public accommodation may file complaints with the United States Department of Justice or pursue other remedies authorized under federal law. The Department of Justice has authority to investigate alleged violations, negotiate settlements, and seek court orders requiring compliance. Because ADA requirements continue to evolve through regulations and court decisions, property owners should seek qualified legal or accessibility professionals whenever questions arise. A real-world example. Suppose your buyer is purchasing a neighborhood retail center. During the due diligence period, the buyer asks whether the shopping center fully complies with the ADA. Rather than providing a legal opinion, you explain ADA compliance can involve technical, architectural, and legal issues. I recommend that your inspector, attorney, or ADA accessibility consultant evaluate the property during your due diligence period. That response protects both your client and your license. Working within your scope of practice, one of the most valuable services a real estate professional can provide is recognizing when an issue falls outside the scope of real estate licensing. ADA compliance often involves architects, engineers, accessibility consultants, contractors, attorneys, and local building officials. Knowing when to refer clients to qualified experts is an important part of professional risk management. Never represent that a property is ADA compliant unless that determination has been made by a qualified professional. Instead, encourage buyers to complete appropriate inspections and accessibility evaluations during their due diligence period. Making legal or engineering conclusions is outside the scope of a real estate license. Online discussion question. Why is it important for real estate professionals to understand the difference between the ADA and the Fair Housing Act? Answer. Although both laws protect individuals with disabilities, they apply in different situations. Understanding their differences helps licensees recognize potential issues and provide appropriate guidance. Question: why should a licensee avoid stating that a commercial property is ADA compliant? Answer: ADA compliance often requires technical, legal, and architectural analysis that falls outside the scope of a real estate license. Buyers should be encouraged to obtain expert evaluations. How does understanding the ADA improve customer service? Answer: recognizing potential accessibility issues allows licensees to better advise clients, recommend qualified professionals, and help buyers make informed decisions during due diligence.